Hello friends, today I am going to take up important questions on commercial law, Partnership Act and Sale of Goods Act. Question number 1. Define partnership and explain its essential elements under the Indian Partnership Act 1932. The answer will be partnership is defined under Section 4 of the Indian Partnership Act 1932 as the relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. Now, the essential elements of partnership. Number 1, agreement between persons. There must be a contract between two or more persons to form a partnership. Sharing of profit. The business must be conducted with the intention of earning and sharing profits. Mutual agency. Each partner must be capable of acting on behalf of the firm and other partners. Now question number 2. Discuss the rights and duties of partners in a partnership firm. Now answer is the rights and duties of partners are governed by section 9 to 13 of the Indian Partnership Act 1932. These provisions ensure smooth functioning and accountability within the firm. Now rights of partners, section 12. Right to participate in business. Every partner has a right to take part in the conduct of business. Right to share profits. Partners are entitled to an equal share of profits unless agreed otherwise. Right to inspect accounts. Partners can access and inspect the firm's book of accounts. Right to indemnity. Partners are entitled to indemnification for expenses incurred in the ordinary course of business. Now, duties of partner. It is under section 9. Good faith. Partners must act honestly and in the best interest of the firm. Accountability. They must render true accounts and disclose full information. Not to compete. Partners should not engage in competing businesses without consent. Now question number 3. Explain the consequences of non-registration of a partnership firm and the mode of dissolution. Consequences of non-registration is given under section 69. An unregistered firm faces several legal disabilities. Number 1, it cannot file a suit against third parties to enforce contractual rights. Second, partners cannot sue each other or the firm for enforcement of rights. However, third parties can sue the firm and registration is not mandatory for criminal proceedings or rights not arising from contracts. Modes of dissolution, section 40 to 44. By agreement, section 40. Partners may dissolve the firm mutually. By notice, section 43. In a partnership at will, any partner can dissolve the firm by giving notice. By court order, if court orders, section 44. A court may dissolve the firm on grounds like insanity, misconduct, or persistent breach of agreement. By operation of law, insolvency or death of a partner may lead to dissolution. Now question 3. Distinguish between a sale and an agreement to sell under the Sale of Goods Act 1930. Answer is according to section 4, a sale is when ownership of goods is transferred immediately, while an agreement to sell is when the transfer is to take place at a future time or subject to conditions. Now, I am giving you point-wise distinction between a sale and agreement to sell under the Sale of Goods Act 1930. Number 1, transfer of ownership. In case of sale, ownership of goods passes to the buyer immediately. In agreement to sell, ownership is transferred at a future date or upon fulfillment of conditions. Second is nature of contract. In sale, it is a completed contract. So, sale is a completed contract. Agreement to sell, it is an executory contract, meaning it is yet to be fulfilled. It is a promise to transfer ownership later. Third, risk involved. In sale, risk of loss or damage passes to the buyer. In agreement to sell, risk remains with the seller until the sale is completed. Now, legal rights. In sale, buyer can sue for delivery, seller can sue for price. Buyer can sue for delivery and seller can sue for price. In agreement to sell, only damages can be claimed until the sale is finalized. Now, insolvency impacts. In sale, seller cannot reclaim goods if buyer becomes insolvent. But in case of agreement to sell, seller can retain goods if buyer becomes insolvent. Remedies for breach. In sale, specific performance or price recovery is possible, but in agreement to sell, only compensation for breach is available. Now, I am giving you an example explaining sell versus agreement to sell. A buyer agrees to purchase a laptop from a seller. The seller delivers the laptop and receives payment immediately. This is a sale because ownership and possession are transferred instantly. In contrast, if the buyer agrees to purchase a laptop that will be delivered next week, it is an agreement to sell. Now, question 4. Explain the concept of implied conditions and warranties in a contract of sale. The answer will be implied conditions and warranties under the Sale of Goods Act 1930 are silent safeguards that protect buyers even when not explicitly stated in the contract. They ensure fairness, equality, and legal assurance in every sale. Implied conditions, these are under section 14 to 17. Section 14A says seller must have the right to sell the goods. Section 15 says goods must match both sample and description in provided. Section 16.1 goods must be fit for the intended purpose. Section 16.2 goods must be of sellable quality unless examined by the buyer. Section 17 bulk of material must correspond with the sample in quality. That is, buyer must be given opportunity to compare bulk material with the sample provided. Now, warranties. Warranty under section 14. These are secondary promises that do not affect the contract but offer protection of goods sold. Section 14B. Buyer entitled to hold and enjoy goods without any interference. Section 14C. Goods should be free from third-party claims. It means that no one other than the buyer has a claim on the goods and the buyer can claim damages if this warranty is breached. Now, question 5. What are the rights of an unpaid seller under the Sale of Goods Act 1930? Answer is an unpaid seller is defined under section 45. An unpaid seller under the Sale of Goods Act enjoys strong protective rights to recover dues and safeguard goods. These rights are classified into rights against goods and rights against the buyer. Now, right against the goods, section 46 to 54. Right of lien. Section 47, seller can retain possession of goods until payment is made. Right of stoppage in transit, section 50. If goods are in transit and buyer becomes insolvent, seller can stop delivery. Right of resale, section 54. Seller may resell goods if buyer defaults, especially after giving notice. Right against the buyer, section 55 to 56. Now, what are the rights of the seller to buyer? Right to sue for price. Seller can legally claim the price if ownership has passed to buyer. Right to sue for damages. If buyer wrongfully refuses goods, seller can claim compensation. A right to repudiate contract. In case of breach, seller may cancel the contract and seek remedies. These rights ensure that seller is protected when the buyer defaults on payment. For example, rights of an unpaid seller. A seller sells 100 bags of rice to a buyer who fails to pay. The goods are in transit. The seller can exercise right to stoppage in transit under Section 50. If the buyer refuses to pay after delivery, the seller can sue for the price under Section 55. These questions will be continued in the next video. So friend, thanks for watching this video. Please do subscribe this channel.